And there we go. Good evening, ladies and gentlemen. Welcome to the Rates and Lanes podcast. I'm your host, Rico Muhammad. My co-host, Mr. Chuck Snow, is on a little bit of a hiatus this week. He and his beautiful bride are out traveling the world. So we wish them safe travels and hopefully a safe return back home. But we got a special surprise for you this evening. Our resident legal expert has come to join us. It's well overdue to come back to the show. Mr. Hank Seaton joins us this evening. So as always, if you don't mind, please, we always welcome your interaction. If you got questions, comments, or concerns, drop them down in the chat. You can drop them down in the chat whether you're looking at us on Facebook, Twitter, and YouTube. If you find any of this information that we give to you guys tonight helpful in any kind of way and you think somebody else might be able to use it, please like, share, and subscribe. Tell a friend to tell a friend about the show. That helps us grow the audience, helps us grow the podcast. And with that being said, and without any much more further ado, I want to welcome my special guest, our resident legal expert, Mr. Hank Seaton, to tonight's broadcast. Good evening, Hank. How have you been?
I've been a busy beaver. I went to a wedding in Richmond this week, and I don't know. Just ask for prayers for folks on the line. I go to the church where the five children where the six people were shot. It's been in the
Oh,
news, and I'm actually on the school board, so it's been kind of a crazy 3 weeks.
yeah,
Been in
definitely
around some
thoughts and
other
prayers
things.
for that.
Yeah, and it's amazing the use that's been made of that though. The town of Nashville's really pulled together a lot, and it's been reaffirming. But anyway, let's without any further ado get on to the regulatory environment. For those of your listeners who've signed up for our monthly newsletter, you'll know that we've been dealing with a number of issues. I guess one persistent one is the future of the independent contractor model. Uh, we've reported that there are two cases that may tangentially affect AB5. It's hard to predict because they're not right on point, but obviously some courts are looking at the crazy laws of California and giving it a second look, which it deserves. How that'll play out, I don't really know. Obviously, AB5 is being enforced out there. I guess the bad news is other states, particularly with a pro union bias, are kind of picking up the same lead from California. And we're having problems over at the Department of Labor. There was a guy, his last name is Wheel, that was appointed back at the end of the last Republican administration. We opposed his him being seated as the Secretary of Labor because he really had a bias. He couldn't be fair. He'd been a union organizer, and in a Republican-controlled Senate, he was denied. So in the place of that, they put when the Biden administration came in, a lady named Sue, SU, and she immediately started kind of a pro labor agenda, trying to rework the court's definition of independent contractors and trying to pass through something called the joint employer status, which would have allowed union elections to go upstream to shippers and brokers. Uh, those things haven't come to fruition yet, but now she's the nominee to be the Secretary of Labor. Uh,
Hold,
he,
hold on a
he,
second. Hold on a second, Hank. You said something that made my antennas go up, and I didn't want to let you get too far down the road. You said that it would allow the unions to be able to go through voters all the way up through the brokers.
well, I don't know that it gets to the brokers. It is what they call a joint employer status. So what it would initially get to is if somebody is working as a for a franchisee that has got, uh, let's say, Holiday Inn is the parent company, they'd be able to go to the franchisee and certify as a bargaining group the Holiday Inn. So
Mhm.
in the context of how it plays out, uh, ultimately the bargaining group wouldn't stop with the named employer, but it would be easier to organize a shipper, say for instance, if its sole supplier that supplied it with widgets or whatever was unionized. So I guess the fear that we opposed it, the fear that we had was a return to the union shop, that it would make it a whole lot easier for, say, in the old days, Kroger was a union shop, and unless you were a union carrier, you couldn't get into Kroger. So, the closed shop rules that some states have in place would be easier to come to pass at the federal level. So it's something that was obviously supported by union types and would affect, say, an independent contractor's relationships very quickly. So, in any event, both of those things are pending. But now Julie Sue's appointment is pending, and a number of people across industries have been looking at opposing that because uh, her reputation with AB5 and as an organizer in California suggests she wouldn't be balanced and fair in in labor type of issues. So that's one of the residual things that people are looking closely at, particularly carriers that have owner operators and trying to figure out uh, how do we keep those independent contractors in the workforce uh, uh, working working for themselves without them, having to go be a 9 to 5 employee. So
I got I got a
go ahead.
question, Hank. I know that the whole employee issue. I know that FedEx was having some major issues with classifying as independent contractors and things of that nature. And FedEx recently came down with a decision that they were going to take everything, that they were going to kind of consolidate everything. And it sounded as if from the release like they were going to go all employee owned once again, or unless I didn't quite understand that. Uh, is that something that might have been from the AB5 situation with them, with the whole owner operator independent contractor situation? Is that may
that may be late breaking news that you've heard. I haven't. FedEx has got kind of an odd model. It's a fleet owner concept in certain of their products where they will go out and hire somebody uh, who incorporates, and let's say, brings his own 15 trucks to the Harley.
right?
They will run with as if they're leased on to FedEx, but the contract says that that corporation is going to be responsible for paying the drivers. So that removes them one step from having to put them on the payroll. The idea there, and they've managed it very carefully, is to use this fleet concept as a way to avoid having to put the drivers on their payroll and open up the door not only to unionization but to wage and hour disputes and all of those kinds of things. So they put that headache on the fleet operator. And then they have an interesting idea that based upon performance, if they have 25 fleet operators, they rank them and they can bid on the designated runs. So it's kind of an intramural competition to allow the fleets to be rewarded for on-time performance
Right.
and that kind of thing. Uh, it's not a perfect system, but they're the 800-pound gorilla in the room, and they have to really protect the model because let's face it, UPS is a union shop, and they're always saying that they're an unfair disadvantage, and so are a number of the legacy LTL carriers that compete with the FedEx ground. So, whatever I've said here, if anybody's listening, is based upon not the fact that I represent FedEx. It's just that I understand the model a bit.
Right. Right. So the other thing that I think has been coming down, another issue has been a lot of fraud that's been taking place within the industry with the I don't know, with the different things from the dispatch services all the way to different situations with chameleon brokers or whatever, however you want to dub it.
Yeah, that's really a topic that has occupied most of my time because the fraud is absolutely rampant. It affects not only small carriers who are the original target of it, but it now affects large and big carriers and brokers. We've had this rulemaking about dispatch services, and we've got this idea about changing around the bond. Well, on behalf of a coalition of about 12 trade associations, we filed comments in both of those. With respect to the dispatch service, uh, uh, we pointed out that since the thing has started, the incidence of fraud has gone through the roof, with people claiming they are the agent of recognizable motor carriers only to defraud people, and then the marquee name carrier saying, "I never knew him, he stole my identity." And as long as there's no registry, no federal follow up, but people out here doing identity theft and saying they represent multiple carriers, it's very easy for them to do bait and switch. So that they would say, "Oh yeah, I represent Rico. He's got imputable safety ratings. I'll book the freight." So they take the freight ostensibly from you at, let's say, $2,000 off the call board, and then they got this partner in crime who's a broker, and he turns around and puts the same load on the call board the next day for $5,000, and some poor schmuck picks it up. Problem is, the guy that picks it up and delivers it never gets paid because the scam lasts for about 60 days, 70 days. And in that time, they can do a little robbing Peter to pay Paul, or they can claim whatever and take quick pay or factor the receivables. And when they play that scam, I've just got one example that I've asked the agency to explain. But the guy that put the scam together was an identifiable ethnic minority in California. He started a brokerage operation in Diamond Bar. Same day he started a carrier operation. I know that because the two doc numbers the FMCSA assigned were within the same thing, like 1004 and 1005. The scam was run for less than 90 days. When he pulled the switch on it, there were 173 carriers that filed claims on his bond, and the bond total was $1.9 million.
Good God.
And so when the agency came out with its bond thing. They said that they were aware, I think, of 144 in excess of bond claims, totaling about $1,000 a piece. And it was all we could do to keep from telling them that this one fraud was happening there. So,
Man,
in any event, the part of our problem has been this: the big guys don't want to admit how bad they're getting taken. Any of your people are listening to some of the other podcasts, they'll hear outrageous stories from drivers of being woken up from their sleep by people who've uh, are stealing the shipper's identity and say, I know you don't have time to make the delivery, but this major shipper has sent me out here to reclaim the load. And since it's power only, you'll be paid in full. And the guy that's picking it up is a thief.
wow,
Yeah,
boy,
that's wild. You can go online and find that one. But what we have done is two things, and your audience needs to know this. First of all, we've got a security and supply chain protocol that ought to be followed by every honest broker and carrier, and it is this: uh, 2/3 to 3/4 of all the truckloads that move in this country do not have the name of the origin carrier on the bill of
right?
lading.
That's that's
Okay,
that's
so
that's
somebody is saying, "Oh well, the consignor can't be bothered." That's really BS. The law requires not a bill of lading, but a shipping receipt, and that shipping receipt needs to establish the chain of custody. So ultimately, the broker, although you may think, well, I'll get back solicited, but he needs to tell the consignor who's picking up the shipment. And the consignor needs to know that if Crescent doesn't show up, he don't load the truck. I mean, that's just pretty simple stuff. And
let's take a second, Hank, to try to unpack this a little bit before we go all the way down the road. Don't lose your point.
okay,
I just wanted to unpack this a little bit for everybody that's listening in, because we try to pride ourselves on this show of giving you really solid information. And the thing about this whole situation that what Hank is talking about, this is more than just going in, signing the bill of lading. You have to understand your responsibility as a carrier and as an agent. If you're a driver, as an agent of that carrier, what happens? The bill of lading is more than just paperwork. It is the actual title of property. So if you don't mind, Hank, we got you here. If you don't mind,
yeah, well, I'll
before we,
unpack that a little bit from the
yeah,
carrier point of view. The protocol, which is put in a shipper or broker contract, says that you, as the carrier, will sign for the load. It's not going to be Rico Muhammad. It's going to be the name of the carrier who's going to sign for the load. And that if you get to the loading dock and the shipper prepared document has got a strange carrier named on it or some broker that didn't hire you, it's ET phone home time. Okay? Because you're being set up. Now, that can manifest itself in several ways. Okay, I've got a client who makes out the bill of lading as a broker, and his bill of lading says send freight bill to X a broker, and then he puts the name of the pickup carrier on the bill. So when collection agencies come to him because somebody screwed up, he immediately says, this is the shipping document. The guy signed for it as the carrier we hired. He's part of the fraud. The driver should have been instructed not to pick up a shipment that showed he wasn't the carrier, because the law requires not that you have a bill of lading that's a contract, but that you issue a receipt It shows the origin, the destination, the commodity, and it's you that's issuing the receipt. It's just like a warehouse receipt. It's an evidence that you are a bailee and not some scamster. Look at it this way. When they start talking about broker fraud, you've got all of these produce haulers where you don't even have broker regulations.
Right.
So all of those guys are particularly ripe for this kind of fraud. I'll tell you all an interesting example, and I won't use names. I've got a client up in the Northeast who put this protocol in place. And about the third week he had it in, he made very clear to his consignors that this was a problem and they should check it out. So he gets a call from a consignor and he says, this is a load of liquor, okay, alcoholic beverages going from New York to California. Why, I don't know. But in any event, the consignor calls and he says, you know, Pepto-Bismol's the name of the carrier, but the guy who's here in broken English says he's with the Choppers Express or something, and he says he's not taking the load to California, he's taking it to Chicago. So, you know, wise old consignor didn't load him. And we quickly figured out that this was a fraud. So we got the load delivered, and lo and behold, the idiot that we tendered it to came back to us and claimed, oh, no, that guy was under a trip lease to us. He just didn't know it. And the guy went so far as to hire a lawyer to try to sue us for defamation because we reported that.
Wow.
Yeah, I mean, it's just.
But I wanted to kind of unpack that so that everybody, I wanted people to understand, because we may have new people that are listening in, and we may have people that may not be.
Yeah,
aware.
if you're a newbie or a small carrier and going to the call board, you have got a duty to check out the dude who's giving you the freight.
Right.
Just because you can go to the FMCSA and see that he has a broker's license doesn't tell you how long he's been in business. It doesn't give you a reference point. In the old days when all business was personal, your qualification to do business was with a broker was, well, so tell me who you've got as carriers that are leased on to you now, and you let him keep talking till after he got through his mother-in-law and his first cousin and
Right.
gave you a name and a phone number that you recognize. You could call up and say, hey, you know, we're in the same fraternity, or you're recommended. Tell me what your experience has been. That very rarely takes place anymore.
Right.
And the call boards, frankly, if they get upset with me, that's okay. But they don't screen who the heck is on the call board. You know, they're not vouching for the bona fides of the carrier or the broker.
There's an easy way to kind of skirt the process. I think that they have parameters in place where you're supposed to have a DOT number, so on and so forth. But there's easy enough to kind of skirt the process to get access to, as simple as just getting somebody else to sign on information.
Well, I can't tell you how many internet frauds we have caught. The guy will have this wonderful website. He'll indicate that he's a broker, but he isn't. And he'll give you a phone number and address of somebody who you think is legitimate, only to find out that the email address looks like it. So
right.
It would be crescent@yahoo.com.
Right.
Okay. So that's where you're to send the paperwork to, and that's ostensibly who's going to pay you. And nobody connects the dots. If you call the 800 number, you think you just dialed the wrong number because you get some hospital in Omaha.
Reading is fundamental, ladies and gentlemen. So we have to make sure that as looking out for our own best interests, we got to make sure that we're reading with a very keen eye, and we're not letting these little minute details slip by, because these minute details, what you may not think is, you may not think of it as a serious situation, like I say with the bill of lading, and you're just going in and you're scratching your name on there, scratching the signature on there, and you're running back out of the door. You got to be a little bit more, and you got to tell this to you, if you have employees, you got to drill this point home, because that's how this is critical to keeping your business in good standings.
Yeah,
And keeping
look
you
at it this way. If you got a reefer on, you're hauling produce, and if you're hauling produce under the FSMA requirements, you got to have a chain of custody,
right.
because I don't know why, but someday, sometime, a terrorist is going to get a load of fresh fruit and vegetables and throw rice in with the rice, and you're going to have, uh, another horror show. So
Right.
there's a good reason, particularly with produce. There are TSA rules that say if it's going to the belly of an airplane, you not only not to have a supply chain, you've got to be very careful how you handle the shipments. So, I mean, there are all kinds of good reasons to be sure that the name on the bill of lading matches the name on the door. If there's any confusion about it, to resolve it before you leave the freight dock.
And if you want to understand this a little bit better, if this has kind of piqued your consciousness and makes you say, well, man, I don't know what I don't know. Hank never asked me to do it, but I'll tell you, my book is a little bit rough for wear. But Hank has
Send
a
me a
book.
note, buddy. The way you push that book, I at least deserve to send you a new one.
Hank has a book out that explains and gets all of this information to you in very readable, very layman's terms where you can understand it, to help keep you out of trouble. This, I affectionately call this the Bible, that Bible of the transportation industry. As a carrier, you got to have this at your desk, in your truck, wherever you are. You got to have it to be accessible, so that you will, if you come across different things, and this will keep you, this has a bunch of different terms and terminologies and contracts and things of that nature, so that you need to be looking out for. But because that's another thing, Hank, I want to get into that in just a second, but he has all of that stuff in this book so that you can be aware and know what to look out for. And if you don't know what those things are, you need to have this book in your arsenal. And you can find this book. I'll put a link here in a little bit. You can find the book on Hank's website. He never asked me to do it, but I just think that it's so important that you have this information. And Hank is gracious enough with his time to come on. I think that everybody should definitely support and just make sure that they have this book for their own well-being. Um, I was getting
I want to tease out another aspect. If any of your listeners are interested in a little tutorial on what to look for to avoid the scamsters, uh, they can get my email, and I'll be happy to share with them some of the thoughts. I'm doing a webinar, actually a convention next week, that involves the people with cargo cats and the people that have for a long time been involved with, I call it strong arm robbery, robbery by theft, when you don't give the stuff voluntarily to somebody. If I thought he's a fraud, he steals it. But in talking with them, and in talking with a wide variety of people, we have concluded that the real issue cross industries in terms of dealing with fraud is the FMCSA enforcing the broker bond doesn't really begin to affect anything. The bond's too measly. It only applies to double brokers. Most of the scams are identity theft. There's larceny by fraud. There's the exempt thing. And moreover, the agency doesn't have any enforcement power. Their total concern, they believe, is with safety. So we discovered that the Office of Inspector General, which is a division of DOT, actually has the authority to prosecute criminal fraud, and they have been taking a few of the most obnoxious cases. So we have instituted uh, an effort to bring this crazy trucking industry together, including people like OADA, TIA, uh, uh, big carriers, big brokers, little brokers, to say if we can agree on one thing, as long as we're an honest person, we need to get the scamsters out of the system. Okay, and it's amazing when you sit down and talk to fellow lawyers who represent big people and to trade associations. Uh, some are not as familiar with it as the truckload folks are, but everybody has been stung. So I say all of that to say that we have launched a major initiative to try to visit with senators and congressmen to help find the funding and to encourage the OIG to establish special prosecutors and investigators to take over the battle of identifying these frauds, developing the cases, and locking some of these dudes up. Because the way it's worked traditionally is they can just uh, evaporate and reopen somewhere else, and people just say, "Oh heck." You know, in
Well,
some cases, I lost $500,000. But
unfortunately, that's the problem. I think the problem, the fly in the ointment, is that they don't. There's not enough people to enforce these things. I think that there are laws on the book, but the agencies are stretched so thin, and they don't have enough manpower to actually go out and regulate
well, yeah,
and
but see,
enforce.
the fact is, the ultimately you have to get a district attorney appointed by the the Department of Justice to take the case, and they have prosecutorial discretion. Well, they're more interested in prosecuting fentanyl cases.
Right,
And from their point of view, and you can understand it, if they're overworked, they don't want to take any case that they know is not a slam dunk.
right,
Okay, so you've got to have all your act together. And some will tell you that we're not going to take a case that involves multiple thefts. We want a theft that's got 7 figures to it at one time. So ultimately, Congress is going to have to push it on special agents who have a desire to prosecute it, and are then going to have to see that the DA's office doesn't dog it. It's going to have to become a priority. And, we've looked at it, and I'm not trying to cast aspersions on the FMCSA. They got their hands full with safety, and they're not able to get safety ratings to put 4,800 people a year, and there's 700,000. So, don't don't look to them to be able to do anything, nor do they have the manpower to examine fraud as opposed to break axes. It's just a different breed of cat for them. But in any event, the time has come for everybody to figure out who their senator and congressman is, and if they have been stung by these kinds of things, to make it known. Because ultimately, the extent to which uh, we've made some contacts so far, they have been very receptive when they understand the nature of the scams. So
so
I'm
Hank,
looking at you, and I've got a United States senator in mind. I want you to go visit, because this is a bipartisan issue. It's not something that you got to count votes and which side of the aisle you're on. It ought to be nearly unanimous as a standalone.
okay.
And I'm at this point. I can tell you, I'm very happy with the progress that has been made. Some of the the big Washington players have indicated that they support this initiative, and it's I'm not going to tell you it's going to be a clean sailing, but I met with one of my trade associations today, and their attitude was, well, yeah, I'll contact my congressman. I've been ripped off, and I know how bad it is. So I think for the next 30 days, we're going to try to be sensitizing the Congress to the fact that we want to be present when they meet with OIG and we talk about how bad it is.
Okay, so Hank, not necessarily switching gears so much, but I wanted to ask a follow up question as well. There recently at Matt's there was a listening session that took place. From what I think you were there, right?
No, I wasn't there, but I did get a report.
Okay, so what are some things that came out of that listening session that we need to be aware of? What are some things that and where should we what should be on the forefronts of our mind as far as the agency is concerned? Different things that we need to be aware of that they got coming down the pike as well.
Well, I think one of the biggest sleeper issues is the reboot of SMS. Comments on that are due on May 15th, and the agency had a number of listening sessions in which they rolled it out, and I've heard a number of presentations. And on its face, it appears to be a kinder, gentler way of prioritizing carriers for intervention. And what happens is there's no mention in the backdrop of what is the problems with SMS that we went through now 13 years ago. There's no mention of the due process issues and the effect of a reboot. And those are issues that have to be raised at this level. Let me give you an example. Congress told the agency 20 years ago that they needed to give a safety rating to all authorized carriers. Now, with the influx of new people under the existing laws, there was no way they could get around to examining everybody. But
Mm-hmm.
every year they examine less. And when they brought in SMS methodology, it had a whole lot of flaws because it wasn't based upon an objective audit. It was based upon a collection of roadside inspections. And those roadside inspections had data flaws. Number one, the little guys weren't inspected enough to be able to let the law of large numbers take effect. So it was very easy for a little guy to get rear-ended twice and look like he had 4 times the national average of accidents. It was very easy for a little guy to have to go across a particular scale in South Carolina and be a drayman and have the guy sitting there and say, "Oh, here you come again," because of prosecutorial issues. So we opposed SMS initially as being unfair to the little guys because it's been inherently unfair to the little guys to have to pay more insurance because they don't have a safety rating to be subject to more nuclear judgments because people take off at your score. And obviously, for a little guy, one accident, it's kind of like if you go and put all your money on B5, chances are you're going to go home a loser. But if you play the roulette wheel long enough, the law of averages says the house is going to do well. So that's kind of the way the numbers work. Well, the reboot is still based upon uh, a reshuffling of the roadside experience, but it's still based upon things like data queuing accidents, uh, a 2-point system for uh, uh, equipment violations. All they've done is rearrange the deck chairs. Our concern is that it looks like under the new methodology, most of the little guys have no chance of ever getting a satisfactory safety rating. They'll just exist in the limbo of unrated, which will always put you at a competitive disadvantage if the shippers don't have a red light, green light. If the shipper figures out that he's going to get sued every time he hires an unrated carrier, unless he does something else, there's going to be a tendency for him to say, "Oh, I'll give that freight to a large broker," and look to him to take the hit if the guy he hires screws up, which means there's a big percentage of your money that goes out for having the surety of a big broker,
Right.
which is a disadvantage to you.
To
Uh,
us.
so what I'm saying is we've got all kinds of issues that need to be raised, and in that regard, we're going to do a fairly comprehensive webinar between now and May 16th, pointing out these various issues and particularly how small carriers are particularly prejudiced. The agency says, among the rest of the stuff, that they've determined, they don't say how, but that the only information that's relevant to the safety rating is the performance in the past year. So if you think about that, that would mean that a guy who's had a satisfactory safety rating for 5 years, it's based upon stale evidence. And at that case, you could, if plaintiff's bar is looking at the SMS reboot as an alternative way to vetting carriers, then get a clean slate every 12 months. But if in any one 12 months you have bad experience, there's no way to level it out. And
so if anybody wants to make comments on the Federal Registry, I just dropped the link right there. You can click on the link. It make it easy for you. You can copy and paste it and take you right over there. But that definitely deserves our attention. So I wanted to try to make it as easy as possible. If you want to make sure that you're to have your voice heard, that's the way to have your voice heard, is to make sure that you jump over there.
And the other thing is, people have got my email. If they want to make comments and they're serious about it, send them to me. I may very well catalog them and refer to them in the filings we'll make for a number of trade associations. In this regard, what we try to do in advocacy and comment is to make the legal argument and then offer supporting affidavits from people who've either been mistreated on broker abuse or whatever the topic, to have real live operators explain why.
And once again, ladies and gentlemen, I want to make sure that people that are listening in, if you got a question with Hank while Hank is on board with us, we always welcome your interaction. All you got to do is drop your question down in the chat. We'll definitely make sure that we try to come to it and get an answer to your question as best as we possibly can. But he's here with us now, so now is a perfect opportunity. If you have a question or anything like that, if you want to shoot it across, we'll try to make sure that we get it over to Hank so that he can take a stab at it and give you some advice or advise you on it. The other thing, Hank, well, I wanted to kind of stay clear of one topic, but you what else did you have in the pipeline that you wanted to make sure that we discussed tonight?
Well, those are the three regulatory issues that need to be addressed before the summer recess. And on all three of those, it's our hope that we'll have an opportunity to basically put in the can a topical Zoom that we can make available through the trade associations with some advance notice, so that people will understand better those three issues and be able to decide whether they want to participate. Uh, for those who may be listening for the first time, we've got a not-for-profit association that's been around since SMS first came around. It's been 13 years ago, and its organizing factor is uh, we take issues that we think are issues of general transportation importance and meet the goals of the national transportation policy, which uh, is the vision of a marketplace that treats everybody fairly and equally. Uh, I say it's laws that treat everybody equally, not the law of the jungle where the large guy dictates the terms, or the jackals come in at night and strip you bare. So as a result of that, it's kind of an organizing force that lets people in niches that otherwise might not have anything in common uh, organize to fight AB5, organized to fight fraud, are equally affected by the reboot of SMS. So, we think it's, you can be one finger, you can be a fist. And
Right.
that's the reason that we look at advocacy as being kind of all embracing. The agency, to give you an example, the agency was talking about, with respect to the bond, calling balls and strikes on the bond if it looked like somebody was being oversubscribed and making them post an additional bond to stay in business. Sounds like a worthwhile thing to do, but the agency's not really particularly in the position to call a ball and a strike on a broker's bond claim without having some kind of adjudication. And they really don't want to take the time to look at all that. So in response, we had two guys who whose identity had been stolen by crooks, and the crooks were retaliating against them for reporting them as bad actors, and they had turned around and loaded up uh, the crediting services with bad reports on the good guys. And so we put in a couple of affidavits for these folks with the caveat that name withheld will tell the agency. But both of these guys said that, they had really been prejudiced by identity theft as a retaliation by the crooks. That's getting pretty doggone sophisticated. But I can tell you from personal experience, I had to tell one guy who was trying to claim he should be paid, although he was a fraudster, that he wasn't going to get paid. And his response to me was, just pay me my effing money. But he went with the full acronym, and he said, after that, I know where you live.
Wow.
Yeah, wow.
Wow.
So what can I tell you? And I've got a client who can top that. He had one of these dudes send him a picture that he got out of social media of my client, his two daughters, and his wife. And the accompanying note said, I don't think your girls would be happy to know how you're treating me.
And boy, I tell you, some people look stoop to low situations, but
So I mean, you tell me with that kind of stuff going on, we don't need the FBI out here working some of these.
right. And boy, I tell you, some you try that with the right person, you'll get your little red wagon fixed that way. I tell you that.
Well, if there are any questions about this, or any of your readers in particular, they're really the demographic that is the front line of this, because ultimately they're the easiest victim to end up providing the service and not getting paid. And that's usually the trigger for the collection agencies and all the up supply chain people to recognize. Now, frankly, I think they've got some culpability. Uh, if they didn't have their own safety protocol, or if the shipment got out of the docks without verifying the chain of custody. But all of that silly litigation over uh, double payment is dwarfed by the size of the full extent of the fraud.
Well, I'm looking at the time, Hank, and I definitely am grateful that you take the time out to come and join us whenever we ask you. You a
We
wealth of
sure burned
knowledge.
off the better part of an hour, didn't we?
Yes, but it's well a wealth of information that we were able to cover. I want to make sure that everyone understands. I want to kind of say this before we wrap up. I've been trying to reiterate this throughout the program tonight. It's a lot of people that have trucking is a very lucrative business, and you can make a really good living in the transportation industry. But here of late, a lot of people have jumped into the industry, and I'm not sure. That's why I wanted to kind of stress some of the different points that we covered tonight, Hank, when it comes to um, the bill of ladings and understanding the whole chain of custody and understanding that whole process. That is just not um, just come in and just, oh, you're gonna start making money. Like there's a lot of stuff that is interconnected, and there's a lot of nuts and bolts. And I want people to really understand the inner workings of how all this stuff kind of ties together and connect the dots to how all of this stuff works within the industry.
Well,
Because
the frustrating thing to me is I've been working with truck companies. I'm now into my 50th year, so a lot of the laws that have been untouched on the books for all that period of time are just very simply disregarded as overtaken by contracting, as overtaken by technology, are just simply unenforced and misunderstood. And what you people are going to get if they uh, use the book are all laws that are still enforceable and still create the guardrails for running down the highway. Right
one
now,
more
there are no guardrails.
One more
And
quick thing, Hank, before I let you get out of here, because now, like I say, with technology and the way things are, a lot of brokerages and everything have gotten to the point now where they have the one-click contract, where you're not allowed to really make any adjustments or changes to a contract. How should our listeners and people that are watching us right now, how if they run across that, if that's a situation where they're in, it may look like a matter of convenience, but how would you advise them to address that situation?
well, that's the fourth topic that I try to rely upon, and that is that the MRIS contracts, the MyPacket.com, are loaded down with adhesion contracts. By that I mean something that take it or leave it. MRIS will say, "Well, we're supposed to vet you, but we can't change the contract. It's take it or leave it." And it's like playing poker. Sometimes you got to know when to hold them and when to fold them. You got to realize that that contract is evergreen, and that means that you may be taking it because you're necessary for one load, and that load may be a load of sand, and the next load they give you may be a sophisticated computer. So if you sign it and says there's no limit on your liability, and they can offset, all of a sudden they got the key to your truck line because you have signed a contract that extends you beyond your insurance. And I do. I've got a presentation on that. I'll be happy to give it to people. It was originally in the book called The Dirty Dozen, which was
Mm-hmm.
12 provisions in a contract that you really got to swallow hard on to figure out how you can price to make money on. It's up to 18 now. and they're really pretty obvious. I was talking to somebody today that said that the insurance companies were uh, now trying to use AI to look at contracts and signify for people what are those issues. Uh, I I don't think I'm artificial or that I've got necessarily any intelligence, but I can tell you that virtually on these contracts, you start with this list, and on most contracts, you can go down them and see the same things.
Right.
So I can tell people look for things like unlimited liability, look for excessive cargo demands, look for homer provisions that says you're going to go to Wisconsin to litigate, look for, they're pretty easy to pick out. And what we try to do, and there are other people that do it, I'm not going to bill a little guy $500 for looking at the same contract that I looked at last week. So we end up having a hit list of, of contracts and how they need to be edited. So if I have some small carrier call up and say, I got Monolithic's contract, can you review it? I say, well, send it to me. I'll run it through my scanner to be sure it hadn't changed in the past 6 months. And if it hadn't, I'll send you my analysis and charge you $50. And
That's
that's that. I think that's a fair price. But my argument to the little guys is, look, you need to establish what is your own offering. An insurance limit that you can afford, $100,000 standard. Carmack Amendment, which said you're not liable for special and consequential damages. Look closely at the indemnity language to be sure that you're accepting liability to the extent you're negligent, not that if something happens and you're within 100 yards of the truck, you're going to buy it. No automatic offsets because your insurance company won't pay the claims. I mean, these things are all really pretty obvious, and it makes acceptance of that RMIS or my packet contract a foolish risk. And what I try to preach to people is, okay, you tell your customer, look, and I tell brokers this, look, if you want to participate in the spot market, set your expectancy at a level that most little guys can literally cover. And it's
right.
just what I've said. Now, if you've got a high value shipment, then tell the little guy he's got to get spot market insurance, and he's smart, he's not going to play in it. Or if you're a big broker, tell your customer that, and tell your customer, hey, it'll be cheaper for you to go get property insurance. But all of those are repetitive things that somebody new getting in the business doesn't really understand. And for NASTIC and groups of small people, we try to preach that and try to teach it.
Right. Well, once again, Hank, you've been more than helpful and gracious with your time and information. I definitely, for one, appreciate it. I know our listeners appreciate it. So if you want to get in contact with Hank, you can find all his information over at www.transportationlaw.net. That's where you can also find the book. But that's the legal website for Hank and his partners. You can find those guys over there. All the information is also a wealth of information over there with a ton of different articles and videos that Hank has been gracious enough to post and put up on his own website. So that's definitely the place to go find Hank. Closing out, Hank, is there anything that you'd like to say
No,
before
all that I can say is I've got a real passion about doing something good for the industry, and it really uh, ends up being the double idea of teaching people how to avoid frauds and getting some cop on the block who's serious about it. And with that said, if there is anyone who finds that they're caught up in a fraud, they can get my number. I can put them in contact with people, hopefully who can help them uh, uh, work out a settlement. You find that rather than go give a collection agency 50% and let them try to leverage a shipper, uh, there may be better ways to resolve that. Find that uh, a convention of victims shouldn't put honest people at loggerheads paying lawyers 50% to get a recovery. It oftentimes is saying, look, let's work out some reasonable settlement where over time we'll all be made whole. And, particularly with the cost of litigation, $5,000 to $10,000 loss to a small guy is big money,
Detrimental.
particularly if he's factoring his receivables. And I'm not unmindful to the fact that my legal buddies can charge you $5,000 and $10,000 and you never get to the courtroom. So we got
Right.
to find a better way to do that.
Right. Well, once again, Hank, thank you again for coming on, taking time out of your schedule to come on and discuss these topics with us. We are definitely grateful for you doing so. Hopefully, you guys found a tremendous amount of value from the conversation that we had tonight. If you don't mind, we humbly ask you, if you found this information useful, tell a friend to tell a friend, share, like, comment on the video, especially if you're on YouTube or anything like that. That helps us get into the whatever the algorithm is and help us get the information and the show out to a
Yeah.
broader audience.
Also, I got to say this. Uh, Rico is on the YouTube with everybody else. If what we have passed on is helpful to you, uh, tell people to dial up rates and lanes, and they can get a lot of good information every Tuesday night. Only once in a while for me, but Rico's show uh, is is free and valuable to the listeners, so I hardly endorse it. There's not a whole lot of small businessmen who can take the time to devote to host a webcast once a week and do what Rico does.
No, thank you, Hank. We definitely appreciate it. With that being said, everybody, we hope everybody out there stays safe, stay healthy, keep it in between the mustard and the mayonnaise, and we'll talk at your same time, same place next week. God bless you, and good night.
Good night.
Good night, Hank.